Hello everyone, welcome back to Law Minds. Today's topic is Schools of Jurisprudence. But before moving forward, please do subscribe this video, and if you find it useful or helpful, then please do share this video or like it. Introduction. So basically, what is jurisprudence? Jurisprudence means the philosophy of law, or can say the knowledge of law, right? It is derived from the Latin word jurisprudentia, which is a combination of two words, that is juris plus prudentia, where juris means legal and prudentia means skill or knowledge. So basically, it is the knowledge of law. Jurisprudence has no universal definition, but yeah, it has been defined by many different jurists. And there are different schools of jurisprudence which have been emerged in the past history, and each school has its own perspective or can say different approaches. So in this video, we will discuss the different schools of jurisprudence one by one. So the first one is Natural Law School of Jurisprudence. In this school, the jurists believe that law is given by a supreme force, that is God, or it is based upon the reasons. So reasons means principles which are just and fair. Basically, any law which are against these reasons or against the divine force, divine law, are not valid. The natural law school is also termed as divine law, law of nature, law of God, etc. As I've told you, divine law means the command of God imposed upon man. And this school focuses on the connection between morality and law and suggests that these both needs to conform to each other. The main proponents of this school are Aristotle and Grotius. Aristotle said that man is part of nature in two ways. Firstly, is a part of the creature of God, and secondly, he possesses some instinct and reasons by which he can shape his will. And if anything goes against his divine law or his reasons, then it will not be considered as a valid law. It will be against the principles of natural justice. Now let's talk about Grotius. Grotius was regarded as a father of international law, and he applied these law principles to the international relations. He gave importance to natural law principles to promote peace and justice at international level in international affairs. So basically, natural law school focuses on the law and morality and the connection between both of them. Now let's move forward to the historical school of jurisprudence, which was founded by Frederick Savigny. This school concentrates on origin and history of legal system, and the theorists of this school argue that law evolves over time in response to historical, cultural, or social developments. Basically, law changes according to the need of people. It is a man-made law, and it said that law is found and not made. And the historical school doesn't believe and support the idea of natural school, which believe that the origin of law is from superior authority and have some divine relevance, because historical school focuses upon the changing need of the people with changing times. The main proponents of remain. Montesquieu was the first jurist of this school who stated in his book Spirit of Laws that law needs to evolve with the change in society. Savigny is regarded as the father of historical school. His theory is based upon that law is found and not made. According to him, law is volcaized, which means people's consciousness or the general will of people. And thirdly, Henry Maine believed in the legal fiction, which means that laws for society are made in advance by every progressive society for the welfare of the society. Now let's discuss the analytical school of jurisprudence, in which law originates from the state and it focuses on the present form of law. It has no concern with past or future laws. It is also known as Austinian school, which is named after its founder Johann Austin, and sometimes it is called as the imperative school because it views laws as command from the sovereign. It is also known as positivism because it focuses on the positive law as its subject matter. It is concerned with law as it is and not with law what ought to be. So So the main jurists of the school are Jeremy Bentham or Johann Austin. So firstly, Bentham in his book Limits of Jurisprudence said that it is a duty of state to provide maximum happiness and maximum liberty. He proposed the principle of utilitarianism. He gave the theory of utility, which means property or tendency of a thing to prevent some evil or procure some good, and consequences of good and evil are respectively same as pleasure and pain. He also endorsed the idea of laissez-faire, which means let the man free, which proposes that state interference in the economic activities of individuals should be kept to a minimum. Another proponent is Johann Austin. He is considered as a father of analytical school of jurisprudence, and his lectures published as the province of jurisprudence determined. According to him, law is a command of the sovereign backed by sanction. He stated that law is a rule laid down for the guidance of an intelligent being by an intelligent being having power over him. He devised this school in England, so this school is also known as English school. Now let's discuss the sociological school of jurisprudence. So Auguste Comte was the first one who used sociology for the very first time, and he is regarded as founding the father of the sociological school of law. The idea of this school is to establish a relation between law and society. The main focus of this school is to create a balance between the state and individual. According to this school, the socio-economic problem of the present time cannot be solved by means of the existing laws, and this school is based upon the logic and not on divine law. And the main proponents of this school are Roscoe Pound or Duguid. Roscoe Pound introduced the concept of social engineering, which suggests that law should be used to promote social justice and welfare. He demands for maximum happiness with less disagreement. For example, Article 19(1)(a), which guarantees some right, that is, right to speech and expression. But on the other hand, the state has given liberty to put reasonable restrictions contained under Article 19 Clause 2. So this 19 Clause 2 keeps a check upon the right provided under Article 19(1)(a), which creates a balance between the welfare of state and an individual and his rights. For every individual, his own rights are supreme, but to create a balance between the interest of people, the law is needed. And Duguid proposed a theory of social solidarity. Now let's move forward to the realistic school of jurisprudence. This school of jurisprudence emerged in the early 20th century, and it prioritized the study of how law operates in practice rather than in abstract principles. The realist school believed that the law originated from judges. It was originated in America and Scandinavia in the 1880s. They considered law as a fact influenced by the feelings of many individuals. It emphasizes the decision of judges and lawyers and aims to understand justice from all perspectives in a case. John Gray, Oliver Wendell Holmes founded American Realism, and Jeremy Frank and Evelyn were other jurists from the school. These jurists focus upon the liberal philosophy, which can be seen through the judgments of Justice D.Y. Chandrachud, an Indian judge. He delivered judgments on the right to privacy, adultery, and famous Section 377 or Nas Foundation case. And according to realists, many factors affect decisions, like it is obligation of a wise, rational, or liberal mindset to deliver judgments impartially and instill the principle of liberalism in our culture while remaining unbiased to any form of communalism. So that was all about the schools of jurisprudence, and these